Okay, sorry about that. So fourth factor, huge effect on the marketplace. If you let something like this happen, then if you let a magazine scoop a publisher like this, allow them to take unpaid, so they've not licensed this, even though they're in a favored category, right? They're news reporters, and we know that news reporting is the type of work that might very well qualify for fair use, which is why you have this case in the first place, right? The nation thought, oh, this is fair use. We're news reporting. We got a copy of this book. We get to scoop it. And the court says, not so fast. There's too much taking of the plaintiff's property here. We think that if we let this type of if we call this kind of conduct fair use, pretty soon you're going to be depriving publishers of their incentive to publish these types of books in the first place, because we all know that leaks will happen. And the problem is that you really are going to deprive the publisher of their profit motive, because very few people are going to buy the book if they can get the information from an article. Okay, so you can, here is the site here. So 471 U.S. 539, you can take a look at that case if you're interested. That's sort of the standard fair use case, at least in literary works. Okay, let's take a look at so what follows here are a series of vignettes, right? So hypotheticals that are actually based on real cases, and you'll see in each of the slides that has the case, there'll be the site. So if you're interested in the case, you can feel free to take a look at it. If you have any questions about them, you can leave me questions, email me questions. I'm always happy to answer questions about these cases. Some of these are really interesting, and I think that you should take a look at them, or the ones that interest you more, because a lot of them are really fun. Okay, so fair use or infringement, you make the call. The first case is called Welcome to Twin Peaks, a complete guide. So a guidebook to the television show. It contains direct quotations and paraphrases from the show. It contains detailed descriptions of plot, character, setting. Obviously, a lot like the Seinfeld case, the creators of the creators of Twin Peaks sue the guidebook for copyright infringement. And what do you think? Fair use or infringement? No fair use, infringement. So Twin Peaks versus Publications International. The citation is there. This case is very important, like the Seinfeld case, in the area of trivia books, right? Like fanzines, webzines, unofficial encyclopedias. We talked a little bit about this. Someone like J.K. Rowling is very insistent on controlling all these types of outlets. I will tell you, though, that even though this case stands for the principle that most of those types of things that are unauthorized would be considered to be infringement, a lot of times that's not pursued by the underlying copyright owner for a reason that you can imagine, I think, which is that a lot of people who own copyrights, a lot of companies who own copyrights, perceive that type of going after people who are writing fan websites and borrowing freely from the work, or trivia books and that type of thing, really is not going to be a very good PR move for them. And in any event, might not be actually depriving them of business, but actually might be contributing to more people buying the underlying work. So a lot of times, these sorts of fan-generated content, even though it can be and probably is subject to copyright infringement lawsuits, a lot of times that's simply not pursued. Okay, let's take a look at another case, the biography of Richard Wright. So Richard Wright was an author, and someone wrote a biography of him, quoting from 6 unpublished letters that he had written and 10 unpublished journal entries that he had made, copying no more than 1% of Richard Wright's letters. And of course, the author, being a biographer, had an informational, sort of public affairs biographical purpose. This is considered to be fair use. De minimis copying, informational purpose, the type of thing that the fair use defense really is meant to apply to. By contrast, and just to show you that these cases are always very fact-specific, and unless you have a case that's directly exactly the same facts, when you're a lawyer advising in this area, you can never be sure when you're advising clients that unless you have direct precedent for what they're doing, it can be very hard to advise someone that what they're doing is fair use. Here's a case that went another way. So a biography of J.D. Salinger, also an author, where the biographer paraphrased large portions of Salinger's unpublished letters. His letters were available at a university library, but otherwise not publicly available. This case said no fair use, that the letters, emphasizing the fact that the letters were unpublished. Again, the unpublished nature of the underlying work can sometimes lead a court to decide that there should not be fair use. And then really what it came down to was that what the biographer took was really the backbone, of the biography, meaning his own work was based largely on what he took from Salinger's work. Okay. Next case, this is a fun case, Flint versus Falwell. So Larry Flint, who's the publisher of Hustler magazine, disparaged Jerry Falwell, who of course is a televangelist, or was a televangelist, in one page of his Hustler magazine. Falwell made several 100,000 copies of that article and distributed them to his followers for fundraising purposes. So basically it was, look at what this pornographer Larry Flint is saying about me. We have to stop this and prevent it. Here's what he's doing. Please send money to my church, essentially. So how do you prevent that from happening, right? If you can't, what's Flint going to do? Well, clearly he's going to sue for copyright infringement. There's really no other way to prevent this type of thing from happening. So the only real right he had was to sue for copyright infringement. What does the court say? Court says fair use. There was no diminishing effect on the marketplace, meaning, the magazine, the Hustler magazine, was already off the rack, so it wasn't like that was going to be sold more. And the court found that Falwell was well within his rights to take that article and distribute it. So that's a fun case you can take a look at if you're interested. Okay, thumbnails. This kind of moving on to the digital world here. So, and this is something that, of course, we're all very familiar with these days. But at one point, this had to be litigated. So a search engine creates small reproductions of images and puts them on its own website. Okay, so just like what you do when you do a Google search and you're looking for images. So you do a Google image search. The thumbnails are for the purpose of indexing and access by the public. Okay, what happens, of course, is there's a lawsuit by the owners of the copyright in the photographs that are being thumbnailed, right? That are being indexed. Copyright infringement. You're copying our underlying work, our photography, and it needs to stop. What's the answer? You probably can all guess the answer because, of course, we have these things now still. So. Fair use, yeah. So in this case, there's certainly a purpose to make works more accessible to the public, right? But the real crux of the decision turns on the fact that the resolution of the small thumbnails are, it's much smaller than the actual full work. So the idea is that if someone is looking for fine photography, right, they are not going to be able to take a little thumbnail and use that as a substitute for the photographer's underlying, full version that has thousands of pixels and much better. Okay, so we're focusing more on that fourth factor, the factor that tends to be so important in these cases. is the defendant's work a substitute for the plaintiff's work in the marketplace? And here the court found that it was not. Okay, this is a really fun case, the Leslie Nielsen parody. So a movie company used a famous picture of a nude and pregnant Demi Moore and superimposed the head of actor Leslie Nielsen. So will remember maybe that Vanity Fair had a cover of Demi Moore when she was pregnant, completely nude, but her body was painted. And so this was a poster for a movie starring Leslie Nielsen. That and the film company basically borrowed the image of Demi Moore, superimposed Leslie Nielsen's head on it, and wanted to use that, or did use that, as a promotional poster for the movie. Court says fair use. Transformative because it parodied Annie Leibovitz's style for comic effect. Okay, so again, we have this notion of parody being something that can be at times protected by fair use. If you are making fun of an underlying work, everything essentially that happens on the show Saturday Night Live, to the extent that it borrows from copyrighted works, like from other television shows or from books or what have you, will be protected by the fair use defense because it is considered to be parody, just like this work was considered to be parody. Okay, another case, similar. A movie company uses a famous New Yorker magazine cover, which is you've probably seen this, the typical New York City resident's view of the world, which has big, New York looms large, and then as you move more west, you see tiny little slivers of the country. The gist of it is that New Yorkers care only about themselves and not about the rest of the country. So the movie Moscow on the Hudson borrowed this image from the New Yorker cover and used it to promote their movie. In this case, no fair use. So read the decision, and then you can tell me why you think this case was a little bit different from the Leibowitz case, the case about nude Demi Moore, and you can let me know. Okay, and finally, another case that you really should read is The Cat Not in the Hat. So this was a book, this is around the time of the O.J. Simpson trial. This was a book that was self-styled a parody. It told the story of O.J. Simpson and his alleged murder of his wife in a style that was reminiscent of Dr. Seuss's Cat in the Hat. So a man this famous never hires lawyers like Jacoby and Myers. When you're accused of a killing scheme, you need to build a real dream team. And then the horrible one knife, two knife, red knife, dead wife. Okay, so obviously the company, Seuss Enterprises, the company that is behind Dr. Seuss's work, was horrified by this parody, since, of course, they make their living off of children's books and children's entertainment, and they were none too pleased to see that the style of Dr. Seuss and the images and the trademarks had been borrowed to make this sort of very adult parody of the O.J. Simpson case. So take a look at the case. No fair use. The court considered that it was not a parody of Dr. Seuss, but rather a borrowing of Seuss's style to make a completely different point. Which brings us to a really important point, and this is where I'll end this lecture, on fair use. And that is when fair use is being used as a defense for something that the defendant says is parody. What's really important to do is to take a look at the defendant's work and to ask yourself a couple of questions. The first is, what is the defendant trying to do here? Is the defendant really trying to make fun of the plaintiff's work in his work? Or is it more that the defendant knows that if he borrows something like Dr. Seuss's writing style, or something like a hook from a song, Pretty Woman, for example, which is something that you'll take a look at in the other materials that I'm posting up here, is it that he was making fun of the underlying work, or is it more that he was just borrowing because he knew that taking that underlying work would grab people's attention? People know about Dr. Seuss, right? It's going to draw eyeballs to your work. People have heard the song Pretty Woman. That's going to draw ears to this new song by Two Live Crew. So the question is it true parody? Is it really that this defendant is trying to say something about the plaintiff's work, to make fun of it, to criticize it, to praise it, what have you? That is a work that's going to look a lot more like it's fair, right? Like it's going to be, like courts would allow that under the fair use doctrine. Satire is the second type. Satire is more, I'm going to borrow this work because I'm not creative enough to come up with something on my own. And so I like this other thing. I'm going to get people's attention by taking from that work. That is the type of work that is less likely, much less likely to be excused by the fair use defense. Okay, that's our lecture on infringement and fair use. And please let me know if you have any questions. Thanks so much, and I hope you guys have a great week.